Good afternoon, everyone. Thank you for tuning in. I'm very excited about the discussion that we're going to have today about the role of the prosecutor in the criminal justice system. And I'd also like to thank our panelists for joining us for this very important conversation, and I will introduce them in a moment. For those of you who don't know me, my name is Catherine Neal Harris. I'm the Alfred C. Glasell III Fellow in Drug Policy at Rice University's Baker Institute. This webinar is sponsored by the Baker Institute Drug Policy Program, and it's offered in collaboration with the Institute's Center for Health and Biosciences, and it's the fourth in a series of discussions about the criminal justice system, racial equity, and public health. It's also part of the Baker Institute's 2020 election series, and as part of that series, we're partnering with Houston Public Media and Texas Tribune to host conversations about critical policy issues ahead of the 2020 presidential election. So this topic is especially timely. District attorneys are elected positions, and there will be many district attorney races on the November ballot, including here in Harris County. We are also at what may prove to be a critical turning point in conversations about racial equity and the criminal justice system. People have been pointing out the flaws in the system for decades, but the reforms that have been enacted often have not gone far enough. They serve to temper anger and criticism for a short time without ushering in the larger, more systemic changes that are needed. But George Floyd's killing and the ensuing protests, combined with the pandemic, have highlighted these problems in a way that to many people seems different. And we hope that we can find opportunity for consensus around criminal justice reforms that are pragmatic and equitable. And so this conversation will focus on one area of reforms, which is the role of the prosecutor. So much focus has been recently on policing, and rightfully so. But conversations about criminal justice reform must also examine the role of prosecutors, who are among the most powerful actors in the criminal justice system. And so in a moment, I will introduce our panelists, who will each talk for about 10 minutes, and then we'll turn it over to questions from our viewers. If you have questions while the speakers are presenting, please submit them using the Q&A function as we go along, and they will be asked after the speakers are done presenting. And again, use the Q&A function and not the chat function. And so now let me introduce you to our esteemed panelists. We have Jami Hodge. She is the director of the Reshaping Prosecution Program at the Vera Institute of Justice. Prior to this role, she served for 12 years as an assistant U.S. attorney in Washington, D.C. In addition, Jami served detailed appointments in the Obama administration in the Office of Legal Policy at Maine Justice and as an advisor for criminal justice and drug policy to Vice President Biden. As the director of the Reshaping Prosecution Program, Jami and her team work with elected prosecutors to end mass incarceration, address racial disparities, and to make offices more transparent and accountable to the communities they serve. Sandra Guerra Thompson, a former New York City prosecutor, is the Newell H. Blakely Professor in Law and the director of the Criminal Justice Institute at the University of Houston Law Center. She chaired criminal justice committees for the transition teams for Houston Mayor Sylvester Turner in 2016 and Harris County District Attorney Kim Ogg in 2017. In 2012, Houston Mayor Anise Parker appointed her as a founding member of the board of directors of the Houston Forensic Science Center, Houston's independent forensic laboratory, which replaced the now closed Houston Police Department Crime Laboratory. In 2015, she became the vice chair for this board, and her recent book, Cops and Lab Coats: Curbing Wrongful Convictions with Independent Forensic Laboratories, addresses reforms needed in police crime labs using transformation of the Houston Crime Lab as an example. In 2009, she was appointed to Governor Perry to the Timothy Cole Advisory Panel on Wrongful Convictions. And we have Kim Ogg, who is the Harris County District Attorney. She is a native Houstonian and attorney of 33 years, board certified in criminal law. As the top law enforcement official in Harris County, DA Ogg has used her first term to divert more than 40,000 drug and mentally ill offenders out of the justice system and into treatment instead, giving prosecutors the ability to prioritize prosecution of violent offenders. Other achievements include advancement of crime victims' rights, independent investigation of all police officer-involved shootings, and recovery of more than $30 million in restitution from offenders to this community. And so now I'll turn it over to Jami, who will get us started.
Thank you, Catherine, and thank you to the Baker Institute for the invitation. I think this is An incredibly timely conversation, and excited to be on this panel with the other esteemed panelists. So the question of rethinking the role of the prosecutor, and I really appreciated Catherine's opening remarks, because for me it is something, one, the name of our program is Reshaping Prosecution. So it is something that we are constantly in thought about. And, I've been privileged to be partnered with a lot of electives across the country to do the work of rethinking the role of the prosecutor. But I think with everything that has happened in our country, particularly, in the last 6 months, that question has taken on a really different meaning and context, as we really find ourselves in a new era. Never, at least in my lifetime, have we seen conversations at this level around issues of race, around understanding the legacy of slavery in our country, about understanding terms like white supremacy and racial oppression, and that these conversations are being held across the country in such, broad and public arenas in ways that we've just never seen before. And so it, one, presents, a requirement for us to think about this question in a very different way, but I also think it presents this amazing opportunity. And so, the other thing I wanted, just in kind of scene setting, that I was thinking about just recently, is I saw on social media that last week was Ruby Bridges' 66th birthday. And for people who don't remember or know who Ruby Bridges is, but she's the subject of the famous Norman Rockwell painting that shows a little Black girl in a white dress on her way to integrate then an all-white elementary school in Louisiana. She was 6 years old at the time, and in that, very famous painting, she's accompanied by 4 deputy U.S. Marshals. There is, a racial epithet at the center of the painting, and what appears to be like a tomato, smashed against the wall. And her birthday, again, last week, and she turned 66. And just that, for me, was just this, kind of reminder that our history is not that distant. The civil rights movement, the Jim Crow before it, slavery before that, and even at the founding of our country, the genocide of Native Americans these are really, sort of formative pieces of our history, and that they're not that distant. And I think what makes me hopeful about this moment is one of the things that we have failed to do as a country is truly reckon with our history. We've seen other models in other countries, both Germany and South Africa, and places where there's been a national sort of movement of, truth and reconciliation and reckoning with what had been done in the past to make sure it's not done in the future. And I think we're at that moment, where we can seize this opportunity. So what does all of this have to do with prosecutors? I think the fact that George Floyd's killing prompted this, and that, there has been all of this attention on police. I think Catherine is absolutely right that this moment and this question is not just about police. And so we hear, I think, one reason why this moment feels very different is this is not the first time we've seen protests in response to the killing of unarmed Black people. What is different this time is what's being demanded. And this time, the demands are not just to arrest and hold the officers accountable. This time, there is a real sustained call for change that is systemic and that actually gets at the root of what allows this to continue to happen over and over again. And so if we think about systemic change, then that must center the role of the prosecutor. We know prosecutors are one of the most powerful, one of the most influential leaders in our system. And so when I hear the cries for defund the police, particularly in my work, I think about this as it's not defund the police as an institution. It is a real recognition that we need to do something radically different in the police state, which is our system. And instead of pouring billions of dollars into a system that promotes carceral and punitive responses that have been harmful at the expense, we know, of, more supportive sort of systems like healthcare and education that actually address the underlying issues. And so when we think about defund the police as being about the police state and a cry for really broader systemic change, then again, that centers prosecutors. And so one of the, important to me lessons about this moment, and one of the things that's important as we think about rethinking the role, is that this is a moment where we need prosecutors to lead. And that leadership is more than just holding individual police officers accountable, because I think it could be very easy for prosecutors to say, oh, this is all about policing. My only response in this is to make sure if it happens in my jurisdiction, we'll do our part, we'll hold them accountable. But this moment is calling for something much, much more than that. And one of the pieces that actually ran a couple weeks ago in Politico, that my team and I sort of worked on behind the scenes with some of the lead prosecutors that we work with, was a series of public commitments made by 5 Black women lead prosecutors from offices across the country that were directly in response to this movement. And so some of those commitments included things like not pursuing no-knock warrants, knowing what happened to Breonna Taylor, not prosecuting peaceful protesters, not just taking the word of an officer in making a charging decision and making sure to review the video, which I think is critically important if anyone's read the police report about the George Floyd incident, which is radically different than what the very awful, nearly 9-minute video showed. So being responsive and concrete about what to do in response in their role, I think is an amazing example. And I certainly, recommend, if folks haven't seen that piece, to see that piece. The next thing that I think is important for prosecutors to do and to think about in terms of the role in this moment is that it's, if it wasn't clear before, I think it is abundantly clear now that any sort of, reform or transformation has to center racial equity, and has to center in a way that is about concrete policy and practice change. And so our team and our work, this is actually something we began thinking about a year and a half ago, because we saw in our own work, and we've seen in other decarceration efforts, that you can, work really hard to do things like diversion and to make sure that people are being connected with services, and to, really rethink our punitive approach. But you can do that and see decarceration, and then unfortunately still see persistent racial disparities, and sometimes not just persistent, but the racial disparities will even increase in response to decarceration efforts. And that if we were going to really tackle this persistent problem, we needed to really do something that was laser focused on this issue. And our work, again, because of the prosecutors that we work with and the platforms they've run on, we in our pilot phase did center racial justice, both as a goal and even in our trainings with line prosecutors. We would make sure to talk about, our history, the legacy of slavery, the similarities that we still see in our current system. And even in spite of that, in our efforts, racial disparities persisted in our work. And so what we did was a year and a half ago, bring together racial justice scholars, those who have been directly impacted and have the lived experience and have been advocating for change, and then lead prosecutors who either ran on these issues or because of their own personal experiences, cared deeply about these issues. And we went on a 6-month journey together to figure out how do we create something that's implementable in prosecutors' offices to tackle this problem. And that led to what we released earlier this summer as Motion for Justice. And so I highly recommend it, if folks have not heard of the website or been to the website, to please check out motionforjustice.org. But what that initiative and what those resources there are about, how to center racial equity in transforming the role of the prosecutor. And so what we wanted to make sure to do was not just that we had guidance materials, and they're there. There's education materials. We wanted there to be concrete action steps. And so there's a section of the site that are 10 action steps that prosecutors can take. And for every action step, it was really important to have a specific racial equity strategy. And I think the best example to point to about that is, we know the importance of diversion. I think there are many offices across the country who have diversion programs. The problem is, if you look at data and see who actually gets the benefit of those programs, you still see disparities. And so if you take a strategy that we think is an important strategy and one that works, but if you then implement a racial equity strategy, what you'll do differently is you will think about not having a cost associated with that diversion program, because who's impacted by a cost? Those who are coming from communities that are already under-resourced. You'll think about whether criminal history should be a consideration at all. If the incident before you is something where it's clear this person needs to be connected to treatment, then whether or not they have a criminal history should not be a bar. And that's just not the case in most diversion programs. Most diversion programs are usually reserved for those who have limited or no criminal history. And so having concrete racial equity strategies that sort of tackle these issues was really important. And you'll find that in all 10 action steps on the website. And so, again, the other thing I'll say just about that, and that really is about the third point that I want to just spend a few minutes talking about, is that, so we need prosecutors to lead in this moment. We need prosecutors to truly center racial equity in their policies and practices at this moment. But the third thing is we have this real opportunity right now to re-envision what justice looks like for our country, to really think about what does safety mean. When we think about the sort of lofty ideals that are central to our system and to the role of the prosecutor, of truth, of justice and fairness, all of those things can mean something very different when you center sort of racial equity in that conversation and you center the experiences of Black people and brown people in other communities. And so when we think about how do we re-envision what justice looks like, how do we respond in this moment, it is really important to understand that the answers don't lie just within the office or within the system. And that in order to really make the most of this moment and to figure out, the best path forward, that has to be done in partnership. And so us working, again, not having no idea George Floyd would happen when we started our journey a year and a half ago. But even, it becoming so much, more apparent and clear about the need for something like this out in the world. It was clear to us that those who are closest to the problem are usually closest to the solution. And so if we want to get to those concrete changes, what are the different steps, the new approaches, that we have to center the voices of those who've been most impacted, who've been most harmed by the system. And so what in the website emotionforjustice.org, what you'll see in a lot of the action steps is steps to take that are in partnership with community. And so ways that we are encouraging offices to really not just learn, history, learn about, our sort of journey as a country, but to actually learn it locally and figure out how in your own jurisdiction, things like redlining and how sort of segregation and other things have impacted which communities, which typically, unfortunately overlap with where you find under-resourced, you find high arrest rates. Even now with COVID, you find more COVID deaths tend to be those same areas. And so understanding that local context, but again, doing that in partnership, like the answer really requires getting out of the office and making sure to interact with those who are closest to the problems. And so, I just wanted, I'm not going to take too much time, wanted to share, those initial thoughts. I'm really looking forward to the Q&A and, happy to share more about the Motion for Justice initiative beyond the site. The last thing I'll share is we are piloting this in 3 offices across the country. At Vera, we're a very data-driven organization. And so we didn't just want to create material, we wanted to actually test it and see if it works. And so we're using data to measure racial disparities in case outcomes. We're doing a 12 to 18 month engagement where we will train staff and change policies and implement. And then we'll measure again to see if we've created something that moves the needle. But with everything going on in the country right now, we didn't want to wait to the end of an 18-month pilot period to push this out. And so we have pushed this out. We are pushing it out. And we're encouraging offices to join us who really want to tackle this and take this on through a more larger campaign. So I'll stop there. I look forward to hearing from the other panelists and engaging in the question and answer.
Thank you, Jami, for your comments. I'm sure that we'll have a lot to follow up on with that in the Q&A. And I would encourage you mentioned the website that you guys have, which is really great. Maybe if you can just put a link to it in the chat, the public chat piece, so that the audience members can access it.
Will do.
Okay, great. And so now, Kim, I'll turn it over to you.
Well, thank you, Catherine. Are we, yes, I was going to ask if we could screen share. Well, first of all, hello, I'm Kim Ogg. I'm the district attorney in Harris County. And today's effort by Baker Institute follows just a steady stream of good policy inquiries, research, and I think solution-seeking policies, which is what a policy institute should do. So thank you for hosting this. I know that I reviewed the material about, what the series was on. And so when it comes to racial injustice, mass incarceration, public health, in the role and changing role of the prosecutor, I decided for my short segment to focus on drug policy, drug enforcement, and because I think it hits all these things: racial injustice, mass incarceration, and public health. And then in terms of other related topics, gosh, there's everything: police accountability, diversion, et cetera. So if we could, we'll go through the PowerPoint quickly. Do you control it, Catherine?
Oh, so actually, I think you can control it with your arrow buttons. You should be able to move them.
Oh, I see. Whoop. Okay, thank you. I don't know why.
Is it working?
Yes. Very quickly, the Harris County District Attorney's Office mission is to make our community safer through evidence-based prosecution and equal justice for all. This means guaranteeing a fair process to obtain a just result for the victim, the accused, and the community in every case. So how does this center on racial justice? I don't think you can have racial justice in America without addressing criminal justice reform. To me, it's front and center in achieving racial justice. And I don't think we get social justice without racial justice. When I talk about prosecution being evidence-based in our mission, that is, to me, what the court system, the justice system, should use. That should always be our standard in how and what we consider in terms of reaching our goals. So equal justice for all is really about applying equal application to everyone. And guaranteeing a fair process, to me, is our role in the system. It is not to achieve a certain result. I believe that should be community driven. We'll get to how this affects drug policy and drug enforcement in just a minute. And then in every case, I really think that individualized justice is what our Constitution contemplates, and that no matter the changing role of the prosecutor, we have to always remember that. Next slide. Okay, I believe that the drug war started in the 1970s, produced even greater racial injustice at a critical time when civil rights were really being implemented. The integration of schools, so many things, the end of Vietnam, or it was coming. So the drug war, to me, created a way for racial injustice to be perpetrated through the law. I agree with many scholars on that point. And what's surprising is that it's continued, and that for all the 33 years that I've been a lawyer, drug enforcement and prosecution has been a majority of our efforts in public safety. I think this is a false premise. I think that the drug war created, in some ways, more public safety problems than it helped. And it completely negated the notion that drug use and drug addiction and drug problems should be treated instead of punished. So it ignored the public health side of what underlies drug policy, which is drugs in our society. Now, we have a number of diversion programs, but instead of go through each of them and spend your time doing that, I want to talk about the reasons that we have them and what they're there to accomplish, and how they reduced, how we set about in a very measurable way, reducing the footprint in drug prosecution. Drug enforcement is generally up to law enforcement, and that's why policing reform and policing accountability, I think a lot of it, that they actually intersect. So we sought to eliminate a couple evidence-based problematic types of prosecution in Harris County. And I started January 1st in 2017. And not all of these happened at once, but they happened fairly quickly. We first changed our marijuana program. We stopped prosecuting, for the most part, misdemeanor possession of marijuana. The most important thing about that program is that, one, Dr. Hodge, it was not a first offender program. Two, it applied to everybody. And the reason that our marijuana program applied to everybody is because if you left it to first offenders, you would get a racially disparate group of people who benefited from the diversion. And that's what the Baker Institute, Drug Policy Institute, was already showing with the incumbent's marijuana diversion plan. So what's important is not exactly how we do it, but for this conversation, it was directed to apply to everybody equally. And another important thing about this marijuana program, it was the first drug policy change implemented by our DA's office under my administration in 2017. We met with all the police chiefs and we talked about how much more time they would have on the street to focus on crimes that their constituents, that they were serving, real public safety, to address real public safety problems. And I think for that reason and for fairness reason, they bought in. But to talk 87 agencies into agreeing to not make arrests for people holding under 4 ounces of marijuana, we thought would, that's a big sell. And when you add no consideration about past criminal history into it, when the program is not contingent on a person's criminal history, that's how you eliminate as much racial injustice and disparity in that type of drug enforcement that you can. So I thought that was a really important program and policy change, and it impacted 10,000 cases a year. That's what we'd had. Now, how many people have gone through it is fewer than that. And I think that shows that fewer stops and even requests for cases, marijuana cases, are being made by police officers. So I think that that's an example of how you can make a program fair for everybody. Trace cases was an evidence-based decision. They were prosecuting, prosecutors across Texas were prosecuting empty crack pipe cases, residue cases. We called them trace cases, but there really wasn't enough evidence to show people had the intent to possess. The pipe would often look empty. This was a huge waste of human capital because people got records after records for it. And in fact, it appears that in some jurisdictions, there was really an attempt to habitualize this type of low-level prosecution so that people would then fall under the habitual crime statute. I don't believe that's what punitive penal laws were ever intended to address. Make It Right is about reintegrating people into the community after they have a dismissal or a served out probation or deferred that makes them eligible for something, a non-disclosure or an expunction on their record. Why is that important? Well, first of all, we serve, by far, the applicants are more minority than not. And so I think it goes a ways to help some racial injustice to make it better. But mostly it makes people more employable, we hope, more houseable, more educatable. There's fewer obstacles in their path. And we do this by reinvesting drug forfeiture funds to pay a volunteer law group to help us do these expungements, because in Texas there is no automatic expungement nor automatic non-disclosure. So that's really what I think we've done that is proactive. I'm having trouble moving the slide. There we go. Thank you. Can you move on to the next, or did I do it? Okay. Next. Okay. And that's it. So here's where I want to just talk about these things in a different avenue of prosecution. Since George Floyd, all eyes and prosecution offices have their police shooting cases front and center in terms of what is important to the public. Civil unrest has occurred. People are marching and exercising their First Amendment rights. And these things they show the level of interest and concern. And I think as elected officials, which most district attorneys and all in Texas are, that we should be aware of that. And we have limited resources, but it is important, I think. It's not that everybody doesn't deserve as much resources as you can give them, but I think in these types of cases that we see a number of these cases arising from the enforcement and the way drug laws are enforced by police. And what we've seen in some of our prosecutions is that there need to be different ways of policing narcotics, that what's been tried is corruptible, that checks and balances can be circumvented, and that ultimately it can lead to more harm through hurting people, and the distrust that builds, especially in communities of colors, for not just policing, but for prosecution. It's just unfair. And I think that if we look at how we can change policies and practices related to drug enforcement issues, that our prosecution policies will more easily change. We won't spend as much time investigating, hopefully, civil rights violations, and we will spend more time on other crimes, prosecuting other crimes that people think are important, crimes generally that hurt people. So I appreciate the opportunity to present. I wanted to take it from this drug perspective. There's lots of things we could talk about in the changing role of prosecutors, but I think nothing more contemporary and important to the public than this.
Thank you, Kim, for your comments. And just so the slides, I know there's a little difficulty in navigating them, but we'll make them available online where we make the recording of this webinar available. So if anyone's interested, I can upload those as well. And so now we'll turn it over to you, Sandy.
All right. Thank you so much, Katie, and it's really my honor to be on this panel. I'm a big fan of both the Harris County District Attorney's Office and District Attorney Ogg, as well as the Vera Institute. As a former prosecutor, I have to say that today's panel already has inspired me, because I know that from my work as a prosecutor in the 80s, narcotics was a main driver of what we did. And we know now that exactly the lessons that District Attorney Ogg's talking about are spot on. So I'm here today really in my capacity as Deputy Monitor for the historic bail reform lawsuit in Harris County called Harris County O'Donnell versus Harris County. And this was a lawsuit that was filed several years ago on behalf of a young woman named Miranda O'Donnell and other plaintiffs, including another young mother named Louisa Magruder. And these were individuals who were arrested in Harris County, charged with low-level nonviolent offenses, and found themselves in the Harris County Jail unable to pay the high money bonds that were set under the policies as they existed at that time. So this lawsuit was settled, and a consent decree was entered last year, and the rules were changed in how cases are handled in Harris County, and they've been changed dramatically. And in so doing, they've changed the role of the prosecutor as well as the role of the defense attorney, for that matter. And so I want to talk a little bit about the current system. So here's just to give you an overview. This is the homepage for the Monitor's website. So last March, this past March, Brandon Garrett, a professor from Duke University, began serving as monitor for this consent decree. And I, as I say, am the deputy monitor. And we're working with a team of researchers from Duke University as well as Texas A&M's Public Policy Research Institute. So this is photographs of the team, and again, we have some very, very talented researchers who are working closely with county officials in all of the offices in justice administration and gathering data regarding how the system is currently working. And so a large part of what we do is to just analyze the data. We're also working with a team from the community, and this is a group that we formed as part to advise the monitor team. These are leaders from Harris County in law enforcement. They are service providers for the homeless, for foster children, for women who are have been incarcerated, as well as immigrants and the survivors of domestic violence. We also have individuals with experience as civil rights leaders, and even some who have been involved in the justice system themselves and have become advocates in the community. So working with this group has really helped us to better understand what's going on in the community, what the needs are of the community, and also really enabled us to connect Harris County officials with this group so that they can hear from them as well how local government can be more responsive to the community. So what has changed? Under the old rules, bail was largely set according to a fixed monetary system. And both of our speakers have touched on today the role of money in the criminal justice system. And this is really at the heart of what was going on in context of bail reform. As I said, Miranda O'Donnell, Louisa Magruder, they were unable to get out of jail, not because they posed a risk, not because they wouldn't come back to court, but only because they couldn't afford the money bail that was set in their cases. Their ability to pay was not taken into account as it was supposed to be under Texas law. They didn't have attorneys to represent them. There were only prosecutors at these hearings. And the defendants were not even allowed to speak. They were advised not to speak. They weren't told about their rights. And these hearings typically lasted 1 minute. Under the current system now, that's all changed. So there's no longer is there a fixed money bail schedule. Most people now are immediately eligible for release without having to pay money. They're released on what's called a personal bond. And judges, for those individuals who are not eligible for release, and those involve people who present a public safety risk, for example, a second DWI, a family violence offense, or other, they have other outstanding warrants or what have you. Those individuals now go to a hearing, and at those hearings, the judges are required to take into account ability to pay in setting any kind of money bail. And they have lawyers now. Defense attorneys as well as prosecutors are present at those hearings, which typically last about 7 minutes now. So here are just some of the data that we've compiled. We've only been at this job for 6 months, so this is very much a preliminary report out of our first 6-month report. The number of misdemeanor cases, as we see, has gone down. Now, 2020, of course, is not completed yet. We're still only in September, but the numbers look to be tracking that we're going to have fewer cases, probably because of COVID. But importantly, right, the percentage of people who, since the rule change took effect in early 2019, the number of people now eligible for release and being immediately released on a personal bond has gone up dramatically. And so you can compare especially to the prior years like 2015, 2016. The default rule was people were not going to get out without having to pay money according to that fixed money schedule. And so you had lots and lots of people who would end up stuck in jail. Once the lawsuit was filed, there was more awareness about this, and we started to see more and more use of personal bond in 2017 and 2018. But it isn't really until the rule change that figure jumps dramatically. Recidivism. This is a concern for the community, for everyone, and one that we've discussed with the District Attorney's Office extensively. Our data shows that when we track the individuals who have who are released on a personal bond or released in any form, how often is another criminal complaint filed against that same person? And looking at this over 90 days, 180 days, and even 365 days, we see the figures there being pretty steady over the course of time. So in other words, even though many, many more people are being released without having to pay any money bail, we see the level of reoffending through 2019 to be pretty much static. Sorry about that. Okay. And racial disparities. This is another big concern of the consent decree. And here too, you see there's a reduction in racial disparities since the changes began to go into effect. This is something that we're still very concerned about. We don't have good data, for example, regarding the Latinx community. So they are categorized as white, and that would change the way that this particular graph looks. But that's a function at this point of the fact that we don't have this kind of data in the Harris County criminal justice system. It's not being collected. So we're going to work with county officials to see how we can better have better racial data and ethnic data. And some other improvements that we've been seeing that county officials have been implementing are really pretty exciting, I think, when you talk about how can we facilitate people coming back to court? It's so critical that they return to court. And one of the things we found is that even the forms people were receiving when they were leaving the jail were not translated into any other language, even though a substantial percentage of the people who go through the system are non-English speakers. And there was no such system in place to send emails or voicemails or text messages to remind people about their court dates, when studies have shown for many years that for most people, all they need is a text reminder and they will come to court. So surprise, surprise, a lot of the people who get arrested are not the most organized, but a simple reminder is all that it takes for most people to show up to court. And now those we're going to have that system in Harris County being implemented for email, voicemail, and text, and it will be translated into Spanish, Chinese, and Vietnamese. And likewise, giving them information about the policies for court appearances and making it possible for them to reschedule some of these court dates. This is another thing that is it's new, and this information will now be available as they exit the jail. There'll be a QR code, there'll be website with translations, and so there's a lot going into this. It's not a simple thing to put the system into place, but it is being implemented now, and I think it's going to really help in terms of making sure people get to court as they're supposed to. And with regard to the prosecutors, as I said, their role has changed now. While they were not party to the lawsuit, nonetheless, they're one of the most important agencies involved in the implementation of the consent decree. So we have been, really pleased to have ongoing dialogue with District Attorney Ogg and her top staff, and we've discussed with them, policies about how they handle bail decisions, recidivism data, and changes to court practices. And as I said, now they are having real hearings with defense attorneys also being on hand to represent people so that they have meaningful representation at those proceedings. So it's very preliminary. This is only the first 6 months, and it's all happening during COVID. It's been very challenging, but at the same time, it's really exciting because I think the preliminary data looks promising. There's a lot of work yet to be done. We'll be at this for the next 6.5 years, but I'm happy to be here to have a chance to report on it and to take any questions. So thank you.
Thank you, Sandy, and thank you to all of the presenters. I think you all provided really, diverse perspectives on this issue, and we covered a lot of ground. I'm going to turn right over to some questions. So the first one I'll ask kind of goes, I think, Sandy, back to your presentation. Someone asked, what % of the people released under pretrial bond actually reoffend within the time periods that you listed out? And then is there a common cause of reoffense across that group?
Can you hear me?
Yes.
Okay. So I'd have to go back to the slide because the slide actually had the percentages, so that could be made available. Yeah. So again, you see the statistics there. So I don't know, what does it look like? 10% after, what is that, 90 days. You have to read it. Under 20% after 180 days. And then some 20-some percent after 365 days. But for us, at least at this point, the important thing is not necessarily the percentages themselves. Clearly these are percentages that we would want to work on, but has the change in the bail policy created a problem for public safety? That's a major concern for us. And at least up until 2019, the data shows it really wasn't. Like the rates of recidivism were very much stable, if not even slightly declining there.
Do we have data on what types of arrests are considered part of the recidivism? I mean, is it usually more violent offenses, or is it more minor offenses, or do we have tracking?
So yeah, we do have some data on that, and but I can't give you the breakdown. I think it probably is in our report, and so I would, to be honest, I'm not really the data person on our team. As you know, we have researchers from Duke University and Texas A&M, and they're much more in tune with the fine details of the data. But most of it is low level of offending. And sometimes you do end up with a felony, but it may be as a result of multiple offenses, right? And so the invocation of a recidivist statute. But sometimes there are felonies as well.
And someone asked that, yes, this webinar will be available on our website for later viewing, and I'll also make the slides available online as well. This next question I'll open up to all the panelists. So we have a question that I guess is kind of a concern about deterrence. And so, in the conversation about reform, what is your response to someone who might say, well, the changes that you're making might, reduce deterrence for committing offenses and balancing those competing issues?
I'm happy to jump in. Can you hear me? So it's actually a question that comes up often in our trainings with prosecutors' offices. And there's actually some great research out of the Department of Justice's NIJ, I'm going to forget what it stands for, but one of the research arms that shows there's actually there's like a misperception that tough punishment leads to deterrence. There is some of that, but that actually what has a greater impact on deterrence is risk of apprehension. And so that's why, if you want to stop 7-Eleven from, having, lots of robberies or people taking stuff out of the store, you'll get better deterrence by putting up cameras or, having something that makes the fear of apprehension more real versus increasing the punishment for robbery. Or I guess that would be, it's a store, so it's not robbery, but for the theft. So there's some great research that shows that. And then I actually saw that question in the chat and wanted to sort of address, there was another piece of that I think it's important, and I appreciate the person for raising it. And part of that question was, so why, it's almost, by treating it, why does racial justice equal treating people differently for, things like drug possession? And I just wanted to, respond for a second to that. The reason we need to treat people differently and have different responses is because the data is very clear that as a system, we treat people differently because of the color of their skin. And so there's, I could actually probably pull the slide, but there's, again, great research that and the question specifically referenced drug possession, that if you look at data on drug possession, Black people, white people use drugs at similar rates, and it's about proportionate to the percentage of the population that we make up. But when you look at then arrest for drug use or drug possession or drug-related crimes, then you find that Black people almost double their population rate in terms of arrests, and that for white people, that rate of arrest comes way down. And then that disproportionality that you see only increases with each step. So not just who's arrested for it, but then who gets convicted, and then particularly who is incarcerated for it is where you see very significant disparities. So the reason we need to do something different is because the way our system operates right now is that we do treat people differently simply because of their race. And that was my point in the part what I was sharing of why it's so important to understand our historical context. If we try and look at these things absent the context of history, then, we can think it's, it's just that person making some decisions or it's a particular office. But when we look at the context of our history, we recognize like there's a lot of hard work we've got to do as a country to do some truth telling and some reckoning, and that these are policy changes that are just trying to fix something that is, really broken at the core. And until we do that deeper work, we're going to have to continue to push to combat the very different treatment that Black people and people of color face in our criminal legal system.
I'd like to add to that. That is a primary reason nothing can be unfair in our system. It's the whole point of it is fairness, but public safety is a concern and issue. And the disparity makes us less safe. The way it's handled through drug enforcement may make us safer if it's directed at behavior that's violent, that's related to drugs. But possession of drugs and the way the enforcement is done from the beginning, I think it just doesn't make us safer. We don't seem to work our way up the chain. We don't seem to have made much of a difference. The cost is tremendous. And the reason I focused on it initially is that's the largest part of the docket. So in practical terms, and just objectively speaking, these two former prosecutors and me spent probably most of our time with regard to docket on drug cases, only to not make anybody safer. And so not only is it racially unfair, it is unjust, it doesn't work, and it needs to change. And the role of the prosecutor is a leadership role, because the public, I don't know that they have the information that they need. They know experientially what's happened. But when you look at the extreme punishment and mass incarceration over drugs that we've had in our country, it's just, and the way it's weakened our workforce, which makes everything harder. I just don't see how we can't accept that responsibility. So I think this has been a good interaction, because you've got academics, I'm in practice, and yet we're just small parts of this. So by getting this message out, I hope that there's more interest in particular policy changes and programs and funding of those programs, treatment programs, other ways of handling, real problems that people have that lead them to drug use, and then the drug use itself becomes the problem. So I appreciate the Institute's interest in this, and thank you, Jamila.
We have time for a couple more questions. I wanted to get to talk about a specific policy change, and Kim, you had mentioned, the diverting of or no longer prosecuting trace cases of marijuana offenses. And I'm wondering what opportunity there is to extend that kind of program. And we can talk about it both here in Harris County and elsewhere, but to extend that kind of thing to other low-level possession offenses. For example, when we talk about, possession of less than a gram, which, is the amount that a sugar packet, and so personal use amount. And so are there opportunities to divert those offenses as well and keep that out of the criminal justice?
And there are absolute, not just opportunities, it's happening every day here in Harris County. I was trying to keep my presentation short, and I neglected to talk about RIC Court. It's an added court where about a third of our drug offenders are rerouted. And it's done really it was a collaborative project between judges and the probation department, the DA's office, and the defense bar, in that most people want drug offenders to be treated, not convicted. And so I think we have a huge opportunity to expand that to almost all drug users just charged with simple possession. One problem is some possession cases are the result of an arrest for a primary crime, something perhaps violent, a robbery or a car chase or something like that. But on these pure possession cases, that is easy. And to a large degree, we're doing it. It's just these courts don't have the capacity. And our other courts then do not always have the same philosophy. And so it's just, it's still a huge part of the docket. And I think working with law enforcement like we did on the marijuana program, it's significant, not because it's easy, it's actually hard. I mean, people don't like change. It's difficult to commit, and it's controversial in the public, and it makes the news. And yet we need to work with law enforcement. If we just executive fiat, I don't think without the buy-in, the program never really succeeds. It can't take roots. And so for our community to get what they want, which is common sense practices in policing and protection while not having their rights violated, I think they can get it. But we're going to have to work with law enforcement, and that's a role of prosecutors too. And we can't see ourselves, we have different jobs. And so when it comes to police accountability and suddenly we're investigating police behavior, this is uncomfortable. And yet this is what has to happen. So there have to be some, I think, ways of making the rules and the playing field level and consistent, at least state by state, until we can get some federal relief. I think these are the issues that people are talking about and want changed.
Thank you. And just, I'm going to go for one more question because I think this is a really important question always for people that are interested in this topic. But, you know, how can, you know, lay people, how can people get, or that are not attorneys or policymakers themselves, influence change out of traditional avenues such as, you know, just voting or marching or that kind of thing?
Do you want me to take that?
Sure. Yeah, I was open to everyone. Yeah.
Okay. So I know that I have been on many panel discussions with District Attorney Ogg around the city of Houston, and there are many organizations around town that people can join that have a real interest in criminal justice. You know, in Houston and in Texas, we have the Texas Organizing Project, for example, that has been very active in this area, and there are many others as well. So I think, you know, individuals can look around and, you know, there's Greater Houston Coalition for Justice, there's the Texas Criminal Justice Coalition, on and on and on. So there's lots that can be done to better inform themselves, to have, you know, discussions at churches where we've had panel discussions out in the community. And so I would urge people to, you know, educate themselves, to read, and then to get involved, because that is how actually a lot of change has happened, even at the state level in Austin. When folks go door to door in Austin and ask for change, they get heard.
I think we have to involve our business community. I think they often set aside criminal justice and don't see how much our worlds intersect, how much criminal justice impacts commerce and a healthy economy, quality of life, attraction of a city, for all kinds of things. Anyway, I think that's one way. Another is jury service. Jury service is more important than ever. People are centric to jurisprudence in this country, and until they believe they have a safe place to gather, they will not assemble as jurors. And so we have a big push by our judges right now to ensure and promote the safety of the NRG Center where jurors are being assembled. And I think that it's a really commendable job. That leadership should be acknowledged, and I wanted to. So there are active ways that you can participate. And for lawyers, taking cases pro bono, working in our Make It Right program just twice a year, volunteering to run people's criminal records or take an expungement or non-disclosure case, you can do something. Join us. Let's reform our system.
Thank you so much for all of you. I'm gonna have to stop it there, even though we do have many more questions, but we have run out of time. And again, I really want to thank all of you for this really great discussion. This webinar will be available online on Baker Institute's website along with the slides. If any of you want to contact me, my information is also available on the website. I invite you to reach out if you have questions about drug or criminal justice policy. We also have a place where you can sign up for our newsletters as well. So once again, thank you to everyone for participating, and I hope that this has been constructive for everyone watching. Take care.